I was told to bang the gavel, so I guess we'll get going here, folks. Thanks, everyone, for staying for the least interesting, least controversial panel of the day. We had a pre-calls and we worked this all out, so we're just going to go down the line and everyone can tell their piece of the solution and we're good to go. No, first, real quick, probably this issue more than any, I feel the need to say that, well, first, it is my goal as moderator not to express any opinions, and if I say anything that sounds like an opinion, it's not really an opinion, but it's my own, not my company's. But we're very lucky today to have a really good panel to talk about, we can call it encryption policy, going dark, anything, you name it. Do a brief intro and then of the panelists and have a few remarks by some folks, and then we're going to try to work down the panel and see if there are any things that we can actually agree on. See if we can narrow down what is actually in dispute, and if we can get to maybe a narrower focus, we'll figure out what is at issue and then talk about what that means for the incoming administration. So first, sitting there, Sasha O'Connell, currently the Chief Policy Advisor for Science and Technology at FBI. She leads the FBI's outreach, liaison policy programming, and international coordination efforts on the going dark encryption issue. Previously, she stood up and led the FBI's first Office of National Policy. I should say everyone has much more extensive resumes. You should read them, but I'm going to shorthand them a little bit. Next to her is Kevin Bankston, who's the director of the New America's Open Technology Institute, where he works to ensure universal access to communication technologies that are both open and secure. Previously, he was a digital rights attorney at the Electronic Frontier Foundation, where he spent nearly a decade litigating internet-related free expression and electronic surveillance issues. Next to Kevin is Kiran Raj, currently Deputy General Counsel at the U.S. Department of Homeland Security, where he oversees and handles cybersecurity and technology legal issues for the department. He previously worked in the Department of Justice, where he was senior counsel to the Deputy Attorney General, and he advised the department's senior leadership on issues including policy-related matters with a focus on national security, cybersecurity, and civil litigation. Finally, last but not least, Danny Weitzner, the director of MIT Internet Policy Research Initiative. He is a principal research scientist at MIT Computer Science and Artificial Intelligence Lab and teaches Internet public policy in the MIT Electrical Engineering and Computer Science Department. From 2011 to 2012, he was the U.S. Deputy Chief Technology Officer for Internet Policy in the White House. He also was an Associate Administrator for Policy at the National Telecommunications and Information Administration in the Department of Commerce, which is very active on a variety of Internet and Internet security-related issues. So with that, I think Kieran was going to kick it off with a brief, try to summarize the issue that we're talking about in a neutral as possible manner.
Yes.
Nothing's truly neutral in this, so after that we'll get some feedback from folks, and then we'll break into some questions.
Yeah, so as Jeff mentioned, I'm currently at DHS, though a lot of my government experience on this issue was informed by my time at the Department of Justice, where I worked on this issue sort of day in and day out for quite a while. So I thought I'd start with just what is the going dark challenge from the government's perspective. And usually we define that as the government's inability to obtain critical information in electronic form, even though we have court authorization to do so. So right off the bat, you can see that the definition is actually much broader than just encryption. It actually covers a whole bunch of non-encryption topics as well. So for example, like data retention. That would be the situation where the government might have a warrant, and we go to a company and we say, we're authorized to get certain information, and the company would say, we'd really like to help you, but we no longer have that information. We've deleted it as part of our normal retention policies. We have other issues like data localization, anonymization, sort of a technical inability to comply. So again, it's a situation where the company would want to comply. It's not an encryption issue. They just can't actually respond to the warrant or the subpoena or the other court authorization that we might have. And so it's important to just keep in mind as we start talking, we're going to focus this panel mostly on encryption, but there are a whole bunch of non-encryption issues as well that affect the government's ability to obtain critical information. But in the encryption space, we tend to focus on two main types of data. The first is data in motion. So this is essentially real-time communication data, so instant messaging, things of that nature. and we have data at rest. So that's data on devices. So the Apple case that all of you are familiar with is an example of a data at rest type of problem. So that's just a quick framework of at least how we think about the going dark challenge from just a more definitional perspective. The other question we always get is, well, how does it really affect your investigations and your prosecutions? And I know we're going to get into some sort of questions on this panel of quantitative data, but for the moment I just want to think about, again, a framework more qualitatively. And there's essentially 4 different ways that the going dark challenge affects our criminal investigations and prosecutions. The first is it affects whether we can prevent a crime before it happens. So that is, do we get access to information that can help us stop a crime before it actually occurs? So that's one type. The second type is, can we solve a crime? So a crime has already happened, and now we want to figure out who did it, and can we get enough evidence to show beyond a reasonable doubt that they actually did and prosecute them in our court of law. The third type is just delay. So we might eventually get the information, but it could be delayed. So instead of getting it, say, on day 1 or 2 or 3, we get it on week 5, week 6, week 7, and that might affect the investigation. And the last one is a diversion of resources, or for the consultants out there, opportunity cost. So that is, what is, if we put 20 FBI agents, for example, on an issue for 2 weeks to get access to information, what could they otherwise have been doing if we were able to get that information easier or in a more timely fashion? So that's just a quick overview and a framework of how we think about the problem, how we think it affects us as part of our investigations and our prosecutions. So I hope that was as non-controversial as possible, Jeff.
Anyone want to go ahead? Okay. Let's. So what I wanted to do is try to throw out a couple of issues that I hope are either non-controversial or close to it, and see if we can get agreement on them, and then we can use that to set the table for the later conversation. First, whatever you call it, there's been a lot of talk about a government mandate here or abroad to build a golden key, a back door, exceptional access, whatever you call it. And it is generally understood that if you take an encryption product and build in a way to access it other than the traditional decryption, you have, in some capacity, in the mathematical sense, weakened it. Any folks agree to that? Is that a correct statement of fact?
Agreed.
One, can we? Let's go get drinks.
I think what we would agree to is there's certainly an impact, right? The degree, the term weaken is interesting one. We think about, we love strong encryption at the FBI, as our general counsel says, full stop. So we love strong encryption. Our cyber mission, there's no doubt we understand that piece. When we talk about access, and we don't think necessarily about exceptional access because these things exist today, right? There are a lot of secure systems which we can get content in partnership with the providers with a warrant. And we see in a lot of instances the cybersecurity benefits actually of having that kind of access, right? The ability to scan for malware, right? And things that people in this room know much more about than myself. So is there an impact when there's an access point? Sure. The question is sort of what's the balance of that impact, right? And we see a number of things happening there. So I would just add that. Yeah,
the balancing is something that, to be fair, the White House, Michael Daniel, has talked about from day one. There's going to be an impact, but it's a balancing factor. But the threshold is there is some impact.
So, Jeff, could I
Sure.
try to make another uncontroversial statement?
You can certainly try.
I'll try two. So the first one I want to try is that there is certainly the question of going dark, of all the technical challenges that law enforcement faces in this new environment. And I take that to be uncontroversial. I take it to be uncontroversial that there are lots of new challenges. I certainly wouldn't challenge that. I think but I think what we also want to take as uncontroversial is that we're here in this room because we are having a global cybersecurity crisis. And that the reason, in a way, that this issue has become so pressing and controversial is that we have what is really essentially a collision of a huge amount of effort from the computer security community, both the academic community, the technical community, the commercial world, that is desperately trying to make our systems more secure. And then running headlong into that enormous effort, which I think uncontroversially everyone would agree is really important. Certainly, DHS agrees, FBI agrees, no one, I don't think, doesn't agree, is this set of requirements which, as far as we in the technical community can understand them, really place real threats on the effort to make the internet environment, the digital environment, more secure. And I want to suggest that the technical concerns that have been raised about exceptional access technologies, I think, are uncontroversial. We at MIT put out a paper about a year and a half ago called Keys Under Doormats. It made 3 just very basic points about looking at the technical risks associated with exceptional access systems. Number one, they would force a kind of an about face in a lot of the important computer security techniques that have been pioneered over the last decade, namely that we've learned in computer security that you don't keep keys around longer than you have to. Exceptional access requires that you keep keys around longer than you have to, except for law enforcement. That's why it's exceptional. Second, we learned, and I think have shown, that exceptional access systems would increase complexity in the systems that we're all building. And we know, I think uncontroversially, that a more complex system is a less secure system. And finally, uncontroversially, if we keep all these keys around, we create more vulnerabilities and more avenues for attack and increasing technical risk. And I'll say we put this paper out about a year and a half ago. It's been pretty widely discussed. No technical expert has come forward to say why it's wrong, to say why we're wrong. I think that there are discussions to be had about degrees of risk, but no one has said that there isn't a substantial additional risk from building exceptional access systems, whether voluntarily or as a result of law. So just pure. So that's my uncontroversial, I hope, statement is that no one doesn't think there's really a lot more risk here.
If I could add to that. I feel like Ron Rivest said it very well on Friday. He's the R in RSA, and he was testifying in the first day of proceedings of a new working group at the National Academy of Sciences that is doing a report on this. They had a workshop earlier in the year. And he said, security engineer man-hours are a limited resource. How many of them do we want spent figuring out how to let law enforcement in versus how to keep China out? And I would add Russia to that list. I feel like there's been a bit of a straw man coming from some in law enforcement saying that the technical community has not been willing to talk about this issue or has been saying some sort of secure exceptional access scheme is impossible. I don't think they've said that. I think they've said, we don't know how to build that, and you certainly don't. And I think what came out of the NIS workshop was a consensus of engineers saying, to build a key escrow system, we all know key escrow is doable. It does exist. But to build a stable, secure, auditable, reliable key escrow system and do that for every secure system that we have and ensure that it remains secure and be able to tell that it's been compromised if it's been compromised, they don't know how to do that. And I think that one important thing to keep in mind is if there is ever some sort of mandate that companies cannot build a product whereby they can't also offer decrypted access, we need to accept the possibility that the answer to that isn't them shoveling hundreds of millions of dollars into figuring out how to build that system. It's going to be simply offering less secure products. And indeed, I think that's the direction that FBI Director Comey has been going ever since the technical community has been saying that exceptional access is dangerous, with a line of argument that is, well, Gmail doesn't have end-to-end encryption. Facebook messages doesn't have end-to-end encryption. We don't consider those horribly flawed, so why don't we just have more of those and fewer, WhatsApps and Signals? I think that is a dangerous direction to go in the context of the cybersecurity crisis that Danny speaks of, and in the context of seeing, former secretaries of state and our political parties being pwned. I think that should point us toward having more of our communications being much more secure.
So we've heard.
I might be getting into controversial statements.
I thought that might happen. So what Danny and Kevin laid out, I think, is one side of the ledger, which is what happens when however you get at it, key escrow, whatever. I'll use the word weaken encryption, change encryption, create access. The other side of the ledger, though, can we agree that however well-intended these tools are to ensure the digital economy, protect civil rights, dissidents, communications, everything, they are also a tool for bad guys, be they criminals, terrorists, or cyber gangs using them to hide malware. Is that any controversy to that statement, that good things can be used in bad ways and are being used in bad ways?
With every other tool ever, yes.
So what we come down to is, am I right? That
and that our ability to stop that is limited, because the knowledge of how to use encryption is out in the world, and we don't, I think, know how to put the genie back in the bottle.
So that was. Thank you for the lead. So my question: let's say in a world, well, first, Sasha, Kieran, do you want to address the other side of the equation I just mentioned at all?
Sure. Do you want to go?
Do you want to go
ahead?
Yeah. No. Sure. Let me just actually jump on one thing Kevin just said, is this idea that because there are products out there, that means that is the way that law enforcement says you should be like that. You should be like to use Kevin's examples, Gmail or Facebook Messenger. And I don't think that's actually the message. The message more is it is hard to reconcile the rhetoric around you're asking for a magic key or a magic unicorn key, or you're going to break the internet if you have products and services out there that use encryption yet allow access to the content, when we see a number of those products and services out in the marketplace today. So I think that's why we focus on some of the commercial products out there today, just to respond to the argument that the sky is falling if law enforcement somehow gets access to information that's encrypted, because there are a number of services out there, whether it's commercial email providers, cloud services, so at scale, frankly, where they're using encryption, yet they maintain access to the content. We don't hear any issues from those companies about their products and services being completely insecure. Now, could there be a different methodology, a different security design where they could become more secure? Probably, but we don't see a lot of those companies adopting them for their current products and services. So I guess that's just one response. So it's not that everything has to be like that, but it's more of an answer to you're going to make the internet fall down.
And can I also add, just to respond to the characterization of sort of what our director is asking for, right? So I just want to clarify that. The director has been really clear, right, first that we have an issue, and we can talk about measuring the scope and the impact and all those things, which I think is important to discuss. I thought the trade-off was an interesting one, but when we think about sort of how much energy we want to spend helping law enforcement and national security, it's important to understand the parameters of the impact. So hopefully we can talk a little bit about that. But just in terms of the characterization of what the director is saying. So he's been really clear, right, that there is a large impact he's concerned about. And then within that, he's been very clear in testimony and speeches and other places that there's really two goals for the FBI in particular, right? The first goal is to keep investigations going, right? So it's not like we say, oh, this is really hard, we give up. That's not an option, right? He always says we sort of have an affirmative obligation. We know we do to keep investigations going in this context. So there's a lot of work being done to figure out what that looks like. Additionally, and this is the part that might err on the side of controversial, he has also said we additionally have an affirmative obligation to talk about this issue publicly, right? Because what the director says is we can't have this country sliding to a place, right, where folks think that law enforcement and national security agencies have authorities or exercising authorities that we don't have, right, that we still have in terms of the authorities, but that are increasingly, in some cases, being diminished. So I just want to be real clear, there's never been an advocacy of any type of solution. That whole discussion in that piece is really about education and making sure that folks are having just the kind of discussion we're having here today, so folks understand the impact and that balanced decisions can be worked.
But I think that leads to an additional question, which is the director has been saying this. He's been saying this for a while. We've actually been having this discussion for 2 years. Now he's saying we're going to have the adult conversation next year, whatever that means. And it leads to the question, at what point can we have concluded this conversation about exceptional access as an issue, and start talking about the other hard problems that we'd have to grapple with to ensure that law enforcement and intelligence can do its job in a world where encryption is going to be common. Recognizing that it's not going to be ubiquitous for the business reasons that, like Gmail and Facebook messages are not end-to-end encrypted, because there are business reasons for that. There's always going to be that cache of data. But I'm concerned that we're not getting to the adult conversation, which is some sort of mandate of accessibility is not a good idea. You hear it from the technical community. You hear it from the companies. You hear it from certain elements of the U.S. government. So when do we get to discuss the set of other issues that are relevant to ensuring that you can do your job in the 21st century? And that's the conversation I most want to have, and that I feel like this exceptional access discussion is holding up.
Can I ask a question? When there's any issue of law enforcement or government access to data right now, it seems like the encryption label is thrown on it. People run to corners and there is no discussion. Do you all, the panelists, have a sense that that label has been misapplied? Or is it always a matter of decrypting data? Are there other, and to get to your point of Kevin, there are other ways perhaps law enforcement can get some, most, all of the data they want without building in exceptional access? Is there a conversation that we need to elevate on that point?
I mean, I think as Karen said right out in the outset, right, when we think about this issue of going dark, which again for us is that intersection of existing authorities and technology, encryption is but one. I completely agree with you, right, is but one element that's having an impact. As Karen started to talk about, data retention, anonymization, data localization, right, it is the full gamut. So actually we say this all the time. We're happy to talk about encryption, data at rest, data in motion, but there's a whole set of other issues that we are talking about concurrently, happy to talk about concurrently as well. So, and then even the earlier conversation about VEP, right, lawful hacking, all of these are a universe of discussions that are incredibly important in this new context. So, the piece the directors talked about is we get asked often, because, again, the FBI ultimately is not a decision maker in this policy space, right? We are, but yet, an informer of impact for better data, better data. So when you hear the director talk about an adult conversation, he's really putting the onus on us to do a better job being able to explain the impact. Because we've been told by others, to your point, to move the conversation. That's something folks are waiting for. So we're continuing to work on that. It's complicated, and I can talk a little bit about that if that would help.
I want to get other responses. The next question I was going to lead into is, what is the conversation? What is the plan? I forget a question. Kevin, Danny, Karen, do you have any thoughts on the question of, are we over-applying the moniker encryption to the question of government access to data?
I mean, this is not a fight that we would like to be fighting in civil society. We're happy to have a broader conversation about access to data. Although if that becomes a discussion about mandatory data retention, I think we're going to have a very similar dynamic to the one we have on encryption.
But at least it'd be a new talking point.
Yeah. But I mean, I feel like there are three issues that we could and do need to be talking about that I fear that we're not getting deeply into because of people retreating to their corners on the exceptional access, or I would say backdoors issue. One is government hacking. If there's more encryption, there is going to be more government hacking, and if there's a great lack of transparency and accountability of how those tools are being used, I would love to see.
They solved the problem on an earlier panel, though. So.
Well, I'd love to see a meaningful policy discussion about that and how we address that. I think that we in the civil society and the privacy community have been saying, it's a golden age of surveillance. There's all this data out there, but we also have to be honest about the fact that there are a lot of, especially state and local law enforcement, that aren't really well educated about what data is out there. And this is not helped along by the fact that sometimes the companies are not particularly forthcoming about what they store and under what legal process they will provide it. I feel like all sides need to work together to ensure that there is a better way for that information to be made clear, both to investigators and to consumers, the public. Whether it's through greater investment in things like the National Domestic Communications Assistance Center at DOJ or the Bureau of Justice Assistance's Cyber Center, or there are models for this kind of, up and down the stack of law enforcement and across with companies, education about what's out there. And I think that if we're going to say golden age of surveillance, we actually need to point to what is available without backdoors. And relatedly, we need to address the issue of cross-border access to data. If you're a cop in the UK dealing with a local crime that requires access to email stored in the US, saying golden age of surveillance to that cop is not going to address his problem. And so we need to figure out how to address the MLAT issue. I'm not a big fan of what's been proposed so far in regard to model legislation on that score, but it's a conversation that we have to have. Those are three really important, really hard conversations where there's actually room for discussion and compromise and solutions. Yeah. I don't think the backdoor debate is one of those things.
So the one sense in which I do think the encryption moniker has been misapplied, probably by both sides, is that I think it's actually it's a kind of a mistaken way of talking about trust. I think that we should remember where this issue this time around came from. It is a direct descendant of the Snowden disclosures and the real or perceived scope of national security surveillance as it affected Silicon Valley companies and how those companies believed they were being affected in the global marketplace. So there's a straight line from uncertainty and doubt about whether surveillance authorities were being handled in a sufficiently accountable and trustworthy way. Tech companies saying we're going to strengthen our technical capabilities in order to reassure the market. And there's certainly there's a real sense in which I might have rathered strengthen global confidence in the U.S. Internet infrastructure by strengthening our laws and strengthening our practices. We did a little bit of that, but I think not enough of that. I think there is still a lot of uncertainty out in the world about how vulnerable communications that flow through the U.S. and particularly flow through U.S. internet companies actually are. I think our European friends have a lot of questions, some well-informed, some not all that well-informed, though there's been a real effort at dialogue there. And so when we and I think I think it plays the same way with the FBI. I think Director Comey has essentially said, don't you trust us to have lawful access to this data? Don't you trust that the courts will supervise the surveillance authorities sufficiently? And I think the answer is no. From a lot of people, certainly a lot of people on this coast of the United States. So I think we can, step through all of these kind of very, geeky policy issues, but we probably need to step back and say, is there a way to reorient the debate so that it's about what the real question is?
And that question is trust in your mind.
That's right. We've heard from a number of senior U.S. government officials, some of my former colleagues in the Obama administration, who've come out and said, in the aftermath of Snowden, well, it might have been better had we been a little bit more transparent earlier on. And so I think that there's really a lot of work to do there. And the reason I think that work is important is because the other thing that's very limiting about the encryption discussion is it presumes that the technology environment is fixed. That if we could just kind of focus in on this particular version of the way the mobile operating systems look and just fix something a little bit here, technically here or there, whatever, we would close the gap. Well, the reality is there's whole new generations of architectures being designed all over the place, and they are being designed from the assumption, very candidly, that the threat model is represented by the NSA. And I think it's a very awkward position for everyone to be in. But I think that will continue, really, until there's some genuine progress on closing the gap, on closing this trust gap. And I think that does require getting past kind of the tit for tat that has gone on. But I think if we don't get past it, if we don't create a situation where we believe the rule of law can be a source of trust, we'll fall back to technical measures like encryption being a source of protection of individual privacy. And that may not be, and in that sense, I think Director Comey is right to raise the issue and say, is this really the direction we want to go? But I will say, the problem is he only raises one side of the issue and doesn't really account for the very broad trust deficit that I think there really is.
So I want to leave some time for questions, but I do want to hit one last topic. The symposium is called Cybersecurity Under the Next President. So put a dual question out there. Kiran and Raj, I know you probably can't speak to political implications under the next administration. So if you all could talk about, maybe Sasha specifically, I said Kiran and Raj, didn't I? Sorry. East Coast time, long night. Sasha, the director has talked about the adult conversation, has talked about, I think, even saying we're collecting data to get ready for next year.
Sure.
If you could give us a preview from the FBI side on how you envision that conversation being structured. And Kevin and Danny, from your perspective, there's no secret that Trump is not a friend of civil society and privacy groups. At least his statements to the press to date have been, he called out Apple specifically, and I'm quoting, Apple ought to give the security for that phone. What I think you ought to do is boycott Apple until such time as they give that security number. How do you like that?
How do you like that? I just thought of it.
Yeah.
That's actually what he said.
I left that part out, but you're more prepared than me. So does that change the approach? Obviously, civil society groups were not in love with the Obama administration's approach. It seems now, though, we are going to be even in a different place. So the question for you all is, does the reality of a Trump administration change your approach to things like commissions or how you advocate, who your audience is? Like, what does that mean to the argument from your side? So, Sasha, why don't you start with?
Sure. So, as has already been referenced, the director has talked a bit about our continuing effort to collect data around this issue, right, to measure the impact of going dark on our ongoing investigations. And it's something we've been working on. So I can, in terms of a preview, we are focused on the 4 categories that Kiran talked a little bit about, right? So one, being able to articulate when are those times where I'm unable to prevent, right? And you may have seen there's some press coverage. The RCMP actually just allowed some reporters in to look at some of their active top secret national security cases that are ongoing and some of those concerns about prevention. So that's one area we're looking at. The second, again, is that inability to investigate and prosecute, right? Where are those places where we're hung up and that this issue is really deterring work in that in response piece? And then the 2 other pieces that are often overlooked, and Karen again mentioned these are incredibly important, is delay, right? So sometimes, yes, we solve the problem, but there's a significant time delay, right? And you obviously saw that in San Bernardino, right? Between the time when we get that phone and we get that court order and when we have access to that content. And what does that delay look like? We're trying to do a better job there. And then the last piece, and what I'm particularly really interested in, is this idea of diversion of resources, right? So again, we get into a phone, we get into a device, or we find another mechanism to get to content. What does it take? And again, it was interesting. I just saw this article and some of the data that RCMP released. They talk about both personnel and non-personnel resources, right, used to get into, for example, one phone, one device. And what impact is that having on other priorities? So we're trying to do a better job there. So as a preview, I would sort of offer to you a matrix of those 4 components, and then we're trying to do quantitative and qualitative work in each, right, to get better numbers and also be able to talk more about some cases in particular. I will talk just briefly, if I can, about some of the numbers we've released this fiscal year. There was just some coverage about this. Our general counsel spoke about this at the National Academy of Science kickoff on Friday, and there was actually, EAD Hess talked about it in testimony last spring. And that is we have been talking this year to try and offer some data into the conversation about what we call CART data, right? So these are devices or phones that have come through our forensic review process, right? And so you may have heard this number most recently, Q4 FY16, sort of 13%. The FBI can only get into 13% of phones. So let me, if I can, just offer a little bit of context for that number. I'll talk about just a little bit. Happy to answer other questions about it. So the first thing that's important to realize is this is not all devices and phones, right, that the FBI comes in contact with. This is a sample, right, that's come through, and we could just, if anyone's interested, I can give you more information about it, that's come through a very specific process and come back to headquarters for review, and importantly has completed forensic review, right? So that doesn't capture things that are in the pipeline working their way through. Those are devices and phones that have come from both state and local and FBI FBI cases. So it actually underestimates the problem because, again, it's not catching everything in the pipeline, and it's definitely not catching everything that's in every investigation. So when you hear that number, again, it's important to us because it's a number we've been able to offer, but it is clearly an underestimation. The other important thing to think about when you think about sort of 13%, and people say, oh, it's only 13%, you're making a big deal about this issue, is, again, that underestimation, but also, just in FY16, that's 886 devices and phones, right? So, we can argue from different perspectives if that's a lot or not a lot. But for us, when we think about, each of those represents a potentially critical piece of evidence in a priority investigation that we're at a dead stop for now, at least on. So for us, for both of those reasons, that's how we sort of caveat and look at those numbers. But as I mentioned, going into FY17 this year, we're looking at a number of other ways to help articulate the parameters of the issue.
So when I think about next steps, I kind of think about them in sort of three different buckets or three different options. The first is essentially the status quo. That is, the market will dictate the type of products and services that are out there. And as we've discussed earlier, some of them will have a security model using encryption where only the endpoints would be able to access the information. So that is not even the provider can and not law enforcement. And there's other products and services where the provider can access the content even though it's encrypted. And in those situations, law enforcement with proper court authorization would be able to access the information. And that's what's going on today. And so really the only issue there is what a particular choice a company makes on their product or service is going to dictate whether law enforcement has access to it. And I think that's the sort of drift model that the director has talked about in the status quo. So that's sort of option one. Option two is this idea of some type of consensus. Like we have this conversation and there's an agreement on here's how we want to move forward. And that could take the form potentially of legislation, guidance, some sort of statement of principles, things of that nature. But it's essentially like we've thought about this. It's a complicated problem. There's a lot of nuance, but we believe that this is the best path forward. So that's sort of option two. And option three, I'd put as sort of external effects, and that could be in two different categories. One would be other countries, right? So what happens if we have mandates from other countries, especially those that are not really inclined to human rights protections or other such rule of law protections, or even if we have countries that are allies and they decide to move forward with particular mandates, how does that affect our U.S. companies when they are overseas, and how does that affect sort of law enforcement here? And then sort of part B of the internal effects is the some type of external event, some type of event that galvanizes folks one way or the other. So I see those as three big buckets of moving forward. You can imagine, for example, like in the second option, the consensus model, that maybe the consensus is we should just go with the way the market goes. The company should just decide, and that's the world we live in for encryption, and we're going to have to live with that. But I think the big difference between one and two is that that's a conscious decision we've made as a society as opposed to just drifting there. So I see those as three big categories. Wow. With emphasis.
Everyone awake now? Yeah.
Ta-dum-dum.
Yeah.
Could I offer just a couple thoughts about the issue going forward, only one of which is about what might be the effect of President-elect Trump. I think, first of all, just from a technical standpoint, the technical facts won't really change, but they'll get a lot more complicated. I mean, we heard the Internet of Things panel. What we understand is that the architectures that we're seeing in networking and computing are only getting more complex and more diverse and more distributed. So any solution that's imposed for legal reasons, good, bad, or otherwise, is going to have to fit into an environment that is more complex, not less complex. And I think that's just it's given. I do try to kind of put myself in a position saying, okay, so if we were going to have a legal mandate of some sort, what would it be like, and how would we even think about it? I spent a lot of time on the original negotiation and drafting of CALIA, and It was a complicated process. And that was a complicated piece of legislation for what is today a fantastically simple network. That is the old telephone network, where it was just basically voice phone calls with 10-digit numbers. And, I mean, it was really simple compared to the environment we have today. And even if you, and there in fact have been suggestions from various people say, well, kind of take the CALIA model and, add a decryption requirement to it. And then what you realize, and by the way, and this applies, I think, to the U.S. framework. I think, as was suggested, our allies like the U.K. and France are certainly thinking about this. The EU is apparently maybe going to think about this. But inevitably, any piece of legislation that's not absolutely draconian is going to have nuance to it. It's as CALIA does. CALIA says you cannot impose a requirement on a network operator that would endanger the privacy and security of other users of the network, or would reduce or would impede innovation. What does that mean? How do you figure that out? I mean, it was a complicated enough question in the very simple telephone network, but in this incredibly diverse digital environment, I think we're in for, if we go down the road of mandates, I think it will be enormously complicated. And I suppose it's possible that the U.S. Congress or some other legislature could just sort of, blunderbuss its way through and say, well, just do it.
U.S. Congress would never.
But, I think when we see the complexity and the political complexity of any legislation in the Internet technology area, we know it's a complicated ride, whichever side of the issue you're on. So I think that even if we think there's a political will to go in that direction, the technical and operational complexities won't go away as a result of that. The final thing I'll say is I do think there's going to be a really interesting question we don't know what the Trump administration is going to look like. We don't know who's going to be Attorney General. We don't know a lot of things. We do know that the Republican House in this session of Congress came to a kind of a pretty clear stopping point. They were supportive of a working group or a commission or something like that. So there was not any huge appetite for legislating in this area. That was a consensus, and I don't know that there's any reason to think that would necessarily change. But I do think, in reference to what both Sasha and Kieran has said, clearly this. I have an image in my mind of this kind of mounting pile of iPhones that are bricked, and someone's going to do a very dramatic stunt at a hearing one day and roll out a big bucket of them and dump them on the hearing floor, so I don't think the issue is going away, but I just don't think it gets any simpler, even if we somehow think there's a political will to make it simpler.
Kevin?
So first I want to comment on these numbers just very quickly, just so I'm clear. That 13% includes phones, tablets, and laptops. It's all mobile devices.
It's all mobile devices, and it's state and local and FBI
Yes.
cases, submitted to CART, completed
And it includes phones that weren't openable or accessible because they were damaged as well, correct?
So it includes phones that got through the process. There's a universe that passwords are not an issue, so encryption's not an issue. So that's in the universe, right? So it's, and SAC Bennett's here with me who would know the answer to this question. Does that number include damaged in devices? I have to check. The no answer. I believe they don't. The 13%, I don't believe it does. The 13% does not include not getting in for non-encryption issues or passwords.
I mean, so I will just add, I'm not sure why that's necessarily an underestimate, in that one could also suppose that there are many devices that are not being sent to the FBI for analysis because they were easily opened and analyzed by the local police.
And similarly, and this is something we're working on in FY17, it's a little bit of inside baseball, but the CART data numbers that we report are actually tracked as a workload measure, right? We didn't start this process, right? CART didn't start this process for policy reasons and implications. So if you think about it, actually there's a disincentive for agents to put phones into that database that they know can't be opened. So it's another reason we think it's an underestimation, right? Because as a workload, that would just create a backlog, right? Which is never good, right, at an agency. So we're working on this in FY17, but we actually have another reason to believe it's an underestimation because, again, that system was created to track workload, and so agents in the field have a phone or a device they know they can't get into, and they know CART's not going to be able to get into back at Quantico, so they may not put it in at all. So there's a lot of nuance to the numbers, and again, this is any time you put a number out, right? There's pluses and minuses.
Welcome any data, including data about how many crimes encryption has prevented. But as for the next year, I'm not going to blow my strategy by telling you about it, just like Trump's not going to blow his ISIS strategy by telling you all about it. But I will say this. I think that Danny was talking about this trust gap around the U.S. government, this trust gap around U.S. companies around the world. That is only going to get significantly worse under a Trump administration, and I think it's going to get much worse here too. I feel that to some extent, privacy advocates and civil society under the Obama administration were somewhat embarrassed or reticent to actually raise civil liberties concerns, and instead have been framing their objections as cybersecurity concerns or economic concerns. I don't think we're going to be embarrassed anymore. I think that in the context of the new administration, there are going to be more people who are willing to say, as I will say now, I think it is wholly appropriate and necessary that Americans, on occasion at least, have the ability to have conversations that the government cannot access. And so I'm proud to continue to argue that, as well as talk about how it would be horrible for cybersecurity and for our economic security around the world.
We have 10 minutes, 9 minutes. Let me open up for questions. Please, if you could identify yourself, and we will take the question right here.
I'm David Zaretsky. This is just a question in my personal capacity that is not directed to Sasha.
I'll try to cover you, Sasha.
This issue of trust and transparency. I've had in my government jobs a terrific relationship with the FBI, but I'd like to ask you whether the director is in a position to be trusted and transparent in light of what happened in the last days of the election, and whether you think there are any effects. The conversations that we talked about are going to need to happen and take place, but I wonder what your views are of whether this director is in a position to do that anymore.
So let me address the technical side of the trust question. The reason for the trust gap is not because there is electronic surveillance under law. It's not because there's an FBI that may seem aggressive to people or not. It's because the U.S. government messed with the technology of the internet, and all of a sudden, stability that technical people thought they had about the way the internet was operating, about the way encryption algorithms worked, about what happened when traffic moved from inside the Google network or inside the Yahoo network, that the technical assumptions about what was reliable traffic flow, what was secure traffic flow, were upended by actions allegedly of the U.S. government. Not that controversial anymore. So when I talk about trust, it's not whether anyone trusts the FBI director or whether he should have or shouldn't have sent a letter or whatever else. Kevin may want to address that, but it's really about whether it's about whether the U.S. government is seen as a kind of a benign force in the way the internet operates, in the way the technology operates, or whether it put its thumb on the scale in some way and changed the technical trust equation. And that is what a lot of people felt happened. And I think Kevin could well be right that there'll be a whole other layer of trust questions that will come up, if nothing else, because we're in this highly partisan environment now. But I think the longer term issue, but the one that I actually think we could work on is one to just make sure that we have confidence in the way the infrastructure works.
Other questions? Everyone back there? Yep.
Sasha, I want to go back to the numbers if I can. So you have 13% of the funds that you can get into. First
So the answer to both is unfortunately no, and it's something we're working on when we talk about our next iteration of data collection, getting better at being able to track at a more granular level and answer some of those questions. And again, previous to FY16, we did not track in this way, so we're not unable to do year over year. Again, something we're working on, and when the director talks about going forward, hopefully at the end of the first quarter of FY17, we'll have some beginnings of ability to talk sort of year over year. But this is all pretty new to us in terms of the focus on external reporting of this. The reportings tend to be for operational reasons in the past, and we didn't collect at this level, so we don't have it.
Other questions? Oh, sorry.
Arabella, Our Network. So most of the conversation has stemmed rightly around some of the device encryption issues. I just had a question, I guess, around encryption of traffic. So more from the organizational perspective, I've heard huge concerns from companies in general around all traffic is going to be encrypted. It's going to make this really hard to do our job from a security perspective. I guess from a panel perspective and even Sasha and Kieran, are there any things that you are looking at that might be helpful there, right? So when traffic is encrypted, there's like meta kind of information and things. I'm just wondering, is there another conversation not just about devices, but also about all our traffic is getting dark too? And that's just hard for many organizations as well as
Absolutely.
Yeah, so I guess there's two types of sort of categories there. One is more of like the instant messaging applications and things of that nature, which generally is more on the consumer side, and that's more of a an issue for law enforcement in some contexts, especially when we have like a wiretap act order or things of that nature. But I think what you're getting at is more of the sort of corporate network environment, where for example, you might not be able to scan for malware because it's inside an encrypted traffic. And so we have seen that issue pop up more, and it's becoming more of a cybersecurity concern from that perspective. And that's why you see actually a lot of providers, like one of the reasons and I think Sasha might have mentioned this at the beginning, like commercial email providers, they don't tend to encrypt end to end because they want to be able to scan for malware and spam and other things where you need access to the content. There are sometimes things you can do with the metadata to try to address some of those issues, but it just really depends on the particular network, the infrastructure in place, and applications that the companies have. But it is actually, it is becoming a bigger issue.
Maybe Danny can answer this better than I can. I mean, it seems like there's an enormous amount you can do without deep packet inspection simply based on addressing information. But also there is a security trade-off in the sense that unsecured HTTP traffic can itself be a vector for attack. I mean, there are injection attacks that can take advantage of the fact that your web traffic is not encrypted. And so having that encryption actually does protect against certain types of attacks. And I think that's a good trade-off, ultimately.
Question number?
I'm wondering if we can get some consensus around the legal issues about what the requirements are for access to data. So in this conversation, law enforcement is always saying, we get a warrant, we get a warrant, we get a warrant. But can we admit that there won't always be a warrant? So for example, border crossing. The government's position is that at the border they can search your laptop and your cell phone without a warrant. Can we admit that that's a situation we have warrantless access to data where the encryption would prevent that? Or, for example, I've seen arguments that if you're not a U.S. person, even if you're inside the United States, you don't get full protection necessarily of the Fourth Amendment. And we do know that there are lots of lawsuits against Immigration and Customs Enforcement for conducting warrantless searches of people's houses and stuff in the context of immigration raids, an issue which I think is even more salient today now that President-elect Trump has promised to deport 2 to 3 million people who are here without documentation in the next little bit of time. So can we get consensus that these searches are not warranted searches and sometimes won't even be with any kind of court-approved legal process because of NSLs or immigration or other arguments that people aren't entitled to the Fourth Amendment?
You mean warranted in the legal sense of warrant?
Warranted in the legal sense that a judge has reviewed it for probable cause and that it's particularly described and that there's actually a reason to believe as opposed to a more indiscriminate search without that probable cause standard, or even in cases where a
Yeah, so I think there's just different contexts in which a search could come up, but the key point is that all searches have to have a legal basis for it. So sometimes it's consent, where there wouldn't necessarily be a warrant. Sometimes there's other theories under which law enforcement can search, and warrant is one of them. I mean, the Wiretap Act is a good example where it's not just probable cause, but you actually have to hit even a higher standard, so it's a probable cause plus, right? You have to show that you've done a whole bunch of other things like trash diving and physical surveillance and a whole bunch of other things. Either you did it or you tried to do it before you can even go in and apply for a Wiretap Act order. So I think that the point is that what we're talking about when we're talking about going dark is when the government has sort of that legal authorization to conduct a search, whatever it might be, depending on the particular circumstances.
I wish we used the right language for that, and I think that also goes to the accurate language for that. And I think that was Danny's point that, about trust, which is that there's a lot of mistrust on the part of Americans and others because many people feel that the legal standards for access are not established.
I'll just add to that. I mean, I think it's fair to say much of the rhetoric coming from law enforcement has been, we just want to get stuff when we have a warrant for it. And as you laid out, there are many cases where that's not going to be the case. I also think it's ironic that as that is being said, over the past 5 years, the FBI and DOJ has continually thrown roadblocks up over us passing a law that would clarify that a warrant is in fact required for the content of your communications, regardless of how old it is. So let's maybe fix that.
So I think I have run out of time. I want to thank the panelists for agreeing on what we could agree on and clarifying what we couldn't, and the great questions. So thank you all for making the trip out here and having this conversation. I'm sure it will continue. Ari, next year maybe we'll have a little different conversation on this. So thank you, panelists.
While the panelists now find their seats, I've got the great honor of introducing our next speaker. I'm David Hoffman, Associate General Counsel and Global Privacy Officer at Intel Corporation. I thought Danny did a fantastic job on that panel of articulating the concept of the need for closing this trust gap. As we've seen today, if we really want to promote better security and cybersecurity, we're going to need data to be able to protect data and networks, and we're going to have to show that we've got the ability to use that data in a responsible way and that the entities that are going to use it are trusted. So if we're going to optimize for both the security and privacy values, we've got a lot of work ahead of us to show that we can do that. At Intel, we've got a project that Paula Bruning and myself and others on our team have been working on called Rethinking Privacy, where we apply the traditional fair information practice principles to these issues to show that it can be done. As we've been exploring that, we've recognized that there's really only a handful of people in the world who in their careers have the right expertise and experience for optimizing for both of those values. We're really fortunate today that we have two of them here in the room. Ari Schwartz, our host, who has dedicated the last 20 years of his career to optimizing for both of those values. And our next speaker, Giovanni Buttarelli. I feel very fortunate to be able to call Giovanni a friend and to have known him for a long time. Most of you will know that he is the European Data Protection Supervisor, and in that capacity is the lead privacy and data protection official overseeing the European Union institutions and providing guidance on the interpretation of European law, which what many of you may not know is that before that he was Secretary General at the Carante, which is the Italian Data Protection Agency. While he was doing that, he actually wrote the Italian data protection and privacy law, and before that was a highly respected member of the judiciary focusing on criminal law and cutting down on public corruption, core elements of having to optimize for both privacy and security. Giovanni's kindly agreed to join us and give us his perspective on what's going on in Europe and his view from across the pond of some of the challenges that we've been discussing today. Giovanni.
Good afternoon, everybody. Thank you, David, for your kind presentation. I'd like to thank Ari and the coalition for your kind invitation to be here today with you. Differently than expected, I had a chance to stay the whole day with you, and believe me, it has been an education and a privilege to hear such an expert and varied opinions about the situations we find ourselves in. I was asked to provide a European perspective. You don't know what risk you are running this time in the afternoon by allowing a Latin to take the floor. He or she will start by saying, I will be brief and you will miss your cocktail hour. But it's more than 7 years that I am, let's say, embedded in Brussels, and therefore, because of this genetic change, you can play safe. I will be very short. Let me say that the European Union perspective is not on cybersecurity, not that much different from the one here in the US. First of all, to start with the title of today's event, our political situation is also in flux. And following the elections this month in Lithuania and Bulgaria, between now and October next year, there will be general elections in further 7 European Union member states, including in particular the Netherlands, France, Germany, and Luxembourg. So, 4 out of the 6 founding members of the EU. This is in addition to the uncertainty around the constitutional referendum in 2 weeks from now in my home country. The very same day, Austria will elect the new president of Republic. And I haven't even mentioned Brexit yet, although, as said, I put all my money that at the end of this long-term comedy, they will stay. And we in Europe are also more vulnerable than ever to cyber attacks. And this unfortunately applies to European Union institutions, agencies, bodies, and offices I supervise. Institutions such as my own, and let me simply refer to a well-documented attack to the systems of the European Parliament and of the Commission back in 2011. The first panel today analyzed the notion of vulnerability. And let me say it is an inescapable fact that vulnerability is intrinsic to the digital society. And this is now recognized in a very recent new law in the EU, the so-called NIS directive, published in the official journal of 19th of July this year. It has to be fully implemented in all 28 European Union member states by 9th of May 2018, so a few days before the deadline to fully implement the well-known General Data Protection Regulation. So we'd like to invite you to spend a few seconds by simply going through the European Union official journal to have a look to this directive, 2016-1148. It relates to security of networks and information systems. And you will see that in its premise and in the preamble, there is a set of recitals focusing on the growing frequency, magnitude, and impact of security incidents. And this is why, with this directive, the European Union is trying to establish an entirely new generation of common and higher. Common is essential for 28 member states, higher, of course, as well. Security for networks, data, systems, and also services. And the preamble is also interesting since it relates to some European Union vulnerable entities. Economic activities, first, users' confidence, then the economy of the Union as a whole, but also an interesting reference to how vulnerability is to be analyzed on a cross-border dimension because of the cross-border movement of goods, services, persons, capitals, and therefore the links to the smooth functioning of the internal market. And finally, the directive is also interesting because of a number of essential building blocks. It provides for a mandatory identification at national level of so-called national strategies. Second, there is an interesting identification of operators of essential services to be particularly protected. And finally, the directive highlights which significant disruptive effects are at stake, and therefore what the role is of the regulated computer security incident report teams. But in addition to the NIS directive, there are some important trends in the EU to be mentioned. For instance, the security breach notification. And I think we have to consider that till today this was a sectoral discipline for simply providers of publicly available electronic communication networks. We have heard that today the Department for Homeland Security has published strategic principles for Internet of Things and connected security. And we have heard from the keynote speech this morning that the first of these principles relate to incorporate security in the design phase. I can stand and subscribe all these principles, including this one. I would only add a reference to users control, as I said, to a question within a question this morning. So I think this is perhaps partly an echo of a new requirement in the European Union data protection regulation for developers to integrate data protection by design and by default into their products and devices, software, and so forth and so on. So as said, under the European Union e-privacy directive since 2009, there's been an obligation in a specific sector. Now the new general data protection regulation extends this obligation to all controllers and processors, and therefore data security is becoming now a much more clear obligation for any company targeting its services at the EU or processing personal information concerning people in the EU. So we don't care about establishment, we don't care about the location of servers, but we see where the services are provided or where people is affected. And if there is a failure to comply, the regulation provides for severe sanction. We import your system on enforcement. With regard to security breaches notification, sanctions are established up to a maximum of 10,000 million euros, or alternatively 2% of total global annual turnover. And one of the questions throughout this discussion has been how vulnerability should be assessed. And I'm happy to say that the European Union Data Protection Regulation provides for a number of tools in terms of scalability. So we would like to make these requirements reasonable and effective in practice. We are working hard with colleagues within the 29 Working Party to be ready in day one, which is midnight of 24th of May 2018. And on top of the priorities for this year, so we do not exclude to conclude this exercise by December this year, we are working on exactly how impact assessments are to be performed by first controller in cooperation with processors. So what it means, risks for the individual, and what the actions to be identified are. But meeting cybersecurity challenges is not simply about the law, and we heard about the importance of information sharing at the international level and between public and private sectors. And I think this is the goal of an important entity where we contributed to establish. It's the Cybercrime Center set out at the so-called European Union FBI Europol in 2013. My institution will become the supervisory entity for Europol as from 1st of May next year. And this is also the goal of the Council of Europe 2001 Budapest Convention, ratified by the US. And in considering the balance of interest between companies, governments, and individual consumers and citizens, of course, encryption has become a pivotal question. The convention is to be applied not only to purely computer-related crimes, but to every kind of collection of evidence involving software and hardware devices. So it's horizontal. It provides for international cooperation. It provides for principles of legal basis, necessity, and proportionality. So this applies to the debate on encryption as well. And we also know that embedding surveillance in communication infrastructure creates long-term security risks. We have been discussing this in the digital age since Professor Susan Landau's prescient work in the early 2000 years. You have heard about a recent joint letter by two ministers of Interior from France and Germany. They expressed grave concerns about the need to access communications data. But then under the Slovak presidency of the European Union, member states did not find an agreement on the suggested solution. And Germany, right after, has declared that encryption remains key to protect the security of systems. So the German policy in allowing people to encrypt data is not going to change. In a couple of months, the European Commission will disclose its final proposal to review e-privacy rules. We are moving from a directive scheme to a regulation which is to be applied automatically to all member states without the need of a transposition. And therefore, the European Commission will reveal by the 11th of January its approach to the protection to right to privacy. In the current e-privacy directive, we have the only provision in the EU forcing member states to protect severely the confidentiality of communication. We have adopted an opinion at DTPS early July to recommend specific solutions on this area. And we know from the case of the data protection retention directive that EU law has to pass the tests of necessity and proportionality, even with regard to potential derogations for national security at a member states level. And as the privacy directive is defining the limits to interception and retention, of course, its reform, which is likely to be completed by end of next year, in my view, will be influenced by the new debate on communications privacy and fight against terrorism. Of course, information security as security of data systems and networks is crucial for the integrity of transactions and development of smart grids, the Internet of Things, the digital single market, just to name a few. And in our view, weakened data security for simply the sake of allowing more pervasive surveillance would destroy trust. You have discussed a lot this point, would undermine not only the European Union single market, but the electronic business as a whole. We understand that encryption has grown into a critical tool to protect the confidentiality of communications. Its use has increased after the Snowden revelations about efforts by public and private organizations and government to gain access to our communication. I don't want here to focus too much on our viewpoint, but let me say that if we create backdoors in our devices or in our encryption schemes, criminals, terrorists, the supposed targets of these measures may abuse the reduced security of our devices and our encryption for their purposes. And therefore, reducing the security of our devices may really endanger our information, our personal data, and even our fundamental rights. So it's actually not a debate, privacy versus security, but it's more a debate, security versus security. And I was surprised to see that deliberate weakening of encryption algorithms used by citizens and business is not the answer. To find this statement in this recent declaration by Europol and ENISA, the European Union Agency for Network and Information Security. So they too are largely on our side. And forcing all businesses and citizens to hand over secret encryption keys to the state isn't the answer either. Of course, a database of system keeping the secret keys for all encrypted communications would be a critical risk for national security. And where included in the review of the Privacy Directive, it would be an early Christmas present for criminals and hostile intelligence services. So what we actually need is targeted surveillance to minimize as much as possible adverse impacts on society and economy. For those of you interested to go deeper into our recent experience, I would recommend to have a look to an important decision by the German Constitutional Court speaking about virtual domicile against by annulling a federal law on surveillance, and to a recent extremely technologically oriented decision by the Italian Supreme Cassation Court dealing with let's say aggressive virus and devices to manipulate our smartphones and to be used as an alternative to encryption backdoors. So we are considering in the EU to which extent reinforcement of law enforcement capabilities may be accompanied by a so-called right to encrypt. A right to encrypt means use end-to-end encryption without backdoors. This is implicit in our current system, but perhaps may be enforced by the review of the e-privacy directive. But of course, as I discussed this morning with Tim Cook, I think we need to look beyond current capabilities to quantum and post-quantum cryptography. I fully share the viewpoint by Sacha O'Connell that encryption is just a small part of a bigger debate, and we need to calculate, as Michele Mosca has argued, whether the security shelf life of current applications and the time needed to deploy quantum-safe tools will be greater or lesser than how long it takes for a quantum computer to break our current public key cryptography tools. So in conclusion, I think we may agree that Europe more or less faces the same threats and challenges as the US. Of course, our system is a little bit different, but it is premised on the very same values of democracy and freedom, and of course the rule of law. As a member of the judiciary with a background on organized crime, anti-mafia, intelligence, I don't know why I'm dealing to personal data protection now. Let me say that what we need is to identify a sustainable mix of reasonable laws and obligations, focusing on, of course, effective enforcement, but also transparency and more cooperation, even the sharing of information. But perhaps we also need to place the interests of the ordinary individual, its expectation, at the center of the encryption debate. And of course, we need to avoid measures which may perhaps address short-term needs, but by creating long-term vulnerabilities for both individuals and national security. I would really hope to be able to organize a similar event in the EU, and of course all of you will be warmly invited. So in conclusion, there are difficult days ahead, but the need to work together has never been more clear than today. So let me simply say thank you for your attention. Thank you for this excellent symposium. Although this is, a conclusive remark, but you are entitled to submit a couple of €1 million or dollar questions. Who is the icebreaker? Fantastic.
What can you share with us about the way that the EU is dealing with cross-border issues with information access? I was researching this issue related to the Cybercrime Convention and whether governments are allowed to remotely access and search computers located in other nations and other countries. And how we're dealing with that issue here now, what happens to the government hacking when the computers might be located in other countries. How is Europe dealing with that same question?
I think it's fair enough to answer that it's a step-by-step approach. We are now trying to fix the problems in the EU in terms of sharing of information. This is an horizontal concern affecting the review of Europol, Eurodac, and the Office of the European Union Public Prosecutor regulations. And therefore, Parliament is working intensively to focus on information sharing, to prevent the duplication of information. And the idea is to complete by May next year a long-term and strategic exercise on interoperability of different databases established since 1985 by using different legal frameworks, different constitutional provisions in the EU, the different treaties, and therefore focusing also on different purposes from border management to law enforcement and even intelligence. I think this exercise may be helpful then to invest then additional energies on the cooperation with the outside world, which is currently taking place largely in the framework of Interpol and the implementation of the Budapest Convention. The European Union is not formally speaking competent for national intelligence. There is one country where national intelligence also means economic well-being. But as said in an opinion we adopted at the DPS, this exception does not relate to the issue of national security in a third country. And also, it does not affect the duty of the EU to protect the values of our treaties. Every time the lack of action by single member states can be a concern, or perhaps where we recognize that some of them are doing something wrong. Notwithstanding this limited competence on national security, even on national intelligence, we started an interinstitutional activity. Right after Snowden revelation, the European Council, which is the summit of the 28 member state head of states and government, adopted two separate high-level resolutions highlighting the need to act in any event. And there are two references to exactly the point you have raised. These resolutions are publicly available in the specific website of the European Council.
The panel prior to this one, we talked about information sharing. And I noticed you talked a little bit about the importance of sharing threat information in order to try to effectuate the tenets of your treaty. The definitions, though, of some of the things that we consider to be personal information in the EU would incorporate IP addresses. I was wondering if you have any thoughts about how you enable the proper flows of information, threat sharing information, to try to stop attacks and threats while properly respecting the laws of the EU regarding data protection.
If you classify IP addresses as personal information, it doesn't mean that you are preventing, reinforced cooperation. It simply means that they should also consider the protection of personal data legal framework, which is now enriched by a specific directive to be implemented by member states. This is in addition to the regulation is part of the data protection package by the 6th of May 2018. And differently from a current framework decision by the Council adopted in 2007, it will be applied to every kind of domestic and international processing of personal data, not only to information to be shared internationally. Having said that, data protection authorities have repeatedly said that IP addresses are in principle but not everywhere to be considered as personal data. And a specific opinion focusing on the notion of personal data contains a lot of examples. More recently, meaning a couple of weeks ago, the Court of Justice landed with a new interesting ruling in the Breyer case, going beyond the decision of DPAs and saying that IP addresses are personal data. They didn't say in any event everywhere, but the wording is a little bit different than the one we used years ago. And this has been said as a prerequisite to conclude that a service or network provider may process this information for a legitimate interest subject to respect to certain requirements. But this is a conclusion very, very short in the end. The large part of the ruling you can easily find in the website of the Court of Justice of the EU. It's the Breyer case. You can easily, even if you type on Google, it will appear in 2 seconds. Well, you deserve the cocktail hour.
Thank you, Giovanni. It was really an honor to have you here all day, and I was really struck by the similarities, as you said, in the threats we face and the concerns we face, the issues we face. So we look forward to working with you as we move forward and finding international solutions. With that, we will end the first Coalition Symposium and mosey out to the salon, as they call it, to have drinks on Mozilla. Thank you very much.